Today being the 25th of June of 2025, the trial of Mr. Simon has continued, and in this video we shall be discussing and showcasing every single thing that happened in the court of law today. Just in case you'll be following close attention to our videos published from Monday of this week up until this point in time, then you should know that Mr. Simon is facing the court of law for a possible bail. And the prosecuting lawyer over time has presented very difficult and stringent bail conditions that Simon must meet. And one of the conditions is that he must submit all of his digital devices. Well, let's see what played out in today's court session. Yes, today being the 25th of June of 2025. Before we kickstart the court proceedings, mind you, we are going to be using illustrative pictures and videos to better portray and discuss our point. These videos and pictures are in no way, shape or form affiliated or related with the official court hearings. For the sake of fact-checking us, please feel free to go to the Paijet District Court official website to get first-hand and the full transcript for yourself. With all of that being said, let's go to the courtroom session and see what followed suit. Yes, the presiding judge kickstarted today's court's proceedings by making an introductory speech. He states, and I quote, "Good morning, ladies and gentlemen of the learned counsel. Before we begin today's proceedings, I wish to remind both parties of the importance of order, clarity, and discipline in the courtroom. This is a court of law, not a place for speculation or performance. I expect all submissions to be direct, well-structured, and focused strictly on the matters before us. Avoid repetition, avoid diversion, present only what is relevant, supported by evidence, and guided by proper legal reasoning. Let us proceed with seriousness. This case deserves it. Keeping in mind our duty to uphold justice fairly without delay, you may now call your first matter." And this, like I said, is a statement presented by the presiding judge. Yes, so the court session has kickstarted fully, and the prosecuting lawyer began by making an introductory speech to respond or to reply to the comments coming from the presiding judge. The prosecuting lawyer states, and I quote, "Much obliged, my lord. We take your direction seriously and fully acknowledge the importance of presenting our case with precision and focus. The prosecution is prepared to proceed in a manner that respects the dignity of this court and the seriousness of the matter before it. We shall rely strictly on the evidence before the court and ensure our submissions are clear, relevant, and within the bounds of the law. With your leave, my lord, we are ready to proceed." And this, like I said, is a statement coming from the prosecuting lawyer. Simon's lawyer had to stand up and make his own acceptance speech or his own introductory speech. He states, and I quote, "Thank you, my lord. We are guided by the court's direction and fully align ourselves with a call for clarity and discipline in these proceedings. The defense is committed to presenting our case in a manner that is both focused and respectful of the court's time. We shall rely solely on admissible evidence and established legal principles, and we trust that the truth will emerge through a fair and a proper process. With the court's permission, we are ready to proceed." And this is a statement coming from Simon's lawyer, known as the defense lawyer. Yes, the presiding judge continued by giving or informing the two legal counsel team of where they stopped in the past court proceedings. The presiding judge stated, and I quote, "In previous sitting of this court, I gave a clear directive that the defendant must make available the content of his electronic devices, specifically those in his possession at the time of his arrest or relevant to the charges before this court. This request was made in good time to allow for proper compliance and to ensure full transparency in the interest of justice. Today, I must ask the defendant directly, are you now prepared to present the content of your devices as earlier instructed? Your answer should be clear and direct. The court expects full cooperation. You may now proceed." And this statement is coming from the presiding judge, asking Simon if he is ready to tell the court the full content of his devices, the full content of his phones, his laptops, his tablets, and all of those stuffs. Yes, just in case you are not following, in the past court session, the prosecuting lawyer told the judge that if they must grant Simon a bail, he must present his devices for further forensic examination. And Simon's lawyer was fully against that assertion coming from the prosecuting lawyer. And that is why the judge informed Simon to see, okay, instead of presenting your devices, can you tell us the content of your devices? And this is where we are right now in the court session. So Simon stood up and said, "My lord, I wish to respectfully inform the court that I am now ready to present the data from my electronic devices as earlier directed. I understand the importance of full cooperation and transparency, and I'm making this step in good faith, in the hope that it will assist the court in considering my bail application. I'm prepared to comply fully with any further instructions the court may give regarding the handling and examination of the devices. Thank you, my lord." And the presiding judge will tell Simon, "Please feel free to give us a detailed analysis of the content of your devices." And this is where things got really, really interesting. Simon stood up and said, "I rise today in full recognition of the instructions previously issued by this honorable court, particularly in relation to my electronic devices and their relevance to the ongoing proceedings. At an earlier sighting, your lordship made it expressly clear that for my bail application to be properly considered, I must demonstrate openness and willingness to comply with all reasonable conditions set by this court, including the forensic presentation and inspection of my communication devices. With utmost respect, I am here today to comply fully with that directive. I have taken the necessary steps to prepare my devices for inspection, and I'm ready to display their content in a transparent and orderly manner. I do so not only to meet the requirements of the court, but to affirm that I have nothing to hide and that I submit myself willingly to the rule of the law. If I may proceed, my lord, I want to start with my very first device, which is my tablet. This is a personal tablet primarily used for reading, note-taking, and browsing. It is nothing heavily used for communication, but out of respect for the court's instruction, I'm including it in this presentation. The tablet is now switched on, and I have unlocked it. At this particular point in time, some officers were asked to stand beside Simon to make sure he doesn't tamper with any of his device's data. Yes, so some officers stood beside him, watching him closely as he unlocked his device and to present relevant details to the court. He continues by stating, "Relevant applications such as my email client, browsing history, and my stored notes are accessible. This includes both personal and professional documents that I use in the course of my daily activities. Should the court wish, an appointed officer may now inspect the device, either in my presence or through a supervised forensic procedure." But the presiding judge said, "No, we're not going to touch your phone or your devices at this particular point in time. We want you to critically give us a detailed analysis and data and the content in your devices." So Simon said, "Well understood." He continued by presenting his second device, which is his laptop computer. He said, and I quote, "Next, I present my laptop computer. This is a central tool in my work and contains files spanning several months, including written documents, communications, and research materials. The laptop has been unlocked and is available for immediate inspection. It contains folders relevant to my professional work, correspondence in form of emails, and some legal research materials that I accessed while preparing for this case. Notably, the laptop also includes access to cloud storage platforms where some of my data is synchronized. I'm prepared to provide access to those cloud services should the court or investigators deem it necessary. All passwords and access credentials have been documented and are available to the appropriate authority in a secure and lawful manner." And now Simon brought up his phones and he states, and I quote, "Finally, I present two mobile phones, one primary and one secondary. These devices are the most frequently used for my day-to-day communication. Both phones are charged, unlocked, and ready for immediate inspection. They contain call logs from recent months, including all incoming and outgoing calls, text messages, both SMSs and messages from platforms such as WhatsApp, Signal, and Telegram. Social media accounts which remain active on devices including Facebook, X, formerly called Twitter, and Instagram, And also I have email applications which are synced and contain records of correspondence relevant to both my personal and professional affairs. For full transparency, I have not deleted or modified any data from these devices. I understand that my tampering with digital evidence would not only violate the trust of the courts, but also amounts to separate offense, something I have absolutely no intention of committing. My Lord, I also wish to state that I'm open to the court's direction as to whether these devices are to be kept in the custody of a natural third party, a digital forensic expert, or an officer of the court. My only request is that the process be conducted fairly, professionally, and without delay, so that my right to seek bail may be properly evaluated. I understand that by presenting these devices, I am placing myself under an additional law of scrutiny that is a burden I'm prepared to bear. My only aim is to show this court that I'm not evading justice, and I'm fully prepared to comply with any lawful condition in pursuit of a fair process. In closing, I respectfully ask the court to note my full cooperation in this matter and to consider this step as a demonstration of good faith, trustworthiness, and obedience to the law. Thank you, my Lord. And this is a full and detailed statement coming from Mr. Simon himself, where he has explained the content of his devices and have shown willingness to submit it to the court if need be. And this is the point where things got really, really interesting. The prosecuting lawyer stood up and said, "Please permit me, my Lord, to make a statement regarding the testimonies and the reviews coming from the defendant." The presiding judge gave the prosecuting lawyer the opportunity and the permission to express his concerns. The prosecuting lawyer states, and I quote, "Much obliged, my Lord. We have listened carefully to the statements made by the defendant regarding the presentation of his electronic devices, and we acknowledged his stated willingness to comply with the court's directive. However, my Lord, while the display may appear cooperative on the surface, the prosecution respectfully submits that mere verbal presentation and physical handling over of devices is not, in itself, conclusive evidence of transparency or completeness. The content of electronic devices, especially in the matters of this nature, must be subjected to full independent forensic analysis. It is not enough to simply open the devices in court or claim nothing has been deleted. Only a thorough and professional supervised examination conducted by a qualified digital forensic expert can truly verify whether the data is intact, there has been any attempt to tamper with or delete critical information. All relevant files, apps, cloud accounts, and encrypted storage have been properly disclosed. Furthermore, my Lord, the prosecution will seek a formal chain of custody to be maintained from this moment forward, ensuring that the integrity of these devices and their content is preserved throughout the investigative process. We are not dismissing the defendant's gesture. Rather, we seek to ensure that this process is done properly, fairly, and with legal rigor, so that the evidence obtained, if any, is admissible and reliable. On that note, the prosecution respectfully asks the Honorable Court to direct that the devices be immediately handed over to a court-appointed forensic analyst. All passwords and accessed credentials be documented squarely and made available only to the appropriate officers. The forensic process begin without delay, and findings be reported back to the court at the earliest opportunity. We believe this is the proper course to maintain fairness, avoid any appearance of manipulation, and protect the integrity of the proceedings. We are grateful, my Lord. And this, like I said, is a full statement coming from the prosecuting lawyer, countering every single thing Simon has said. This prosecuting lawyer wants Simon to actually present his devices to a forensic analyst rather than a court official or officer. At this particular point in time, the prosecuting lawyer said he asked the judge to please grant him the permission to cross-examine Simon, that he wants to ask Simon some basic questions about his devices, some basic questions regarding his claims, and some basic questions regarding his case. And the presiding judge, interestingly, gave the prosecuting lawyer the right and the green light to examine or to cross-examine Simon, who was standing and waiting to be questioned. And now, let's listen to the cross-examination between the prosecuting lawyer and Simon, the defendant. The prosecuting lawyer started by saying, "Thank you, my lord, for agreeing for a cross-examination." He continued by saying, "Mr. Defendant, just to confirm, you stated earlier that you are presenting your electronic devices in full compliance with the court's directive. Is that correct?" Simon said, "Yes, that is correct." The prosecuting lawyer said, "And this includes a tablet, a laptop, and 2 mobile phones. Is that correct?" Simon said, "Yes." The lawyer said, "Now, you say you have not deleted or tampered with any content on those devices. Is that your sworn position before this court?" Simon said, "Yes, I have not tampered with any data whatsoever." The lawyer continued by asking, "Let me ask you this. When exactly were these devices last used by you before they were presented in court?" Simon said, "I only got access to my devices before the court session kickstarted." The lawyer said, "So you have physical control, or you had physical control over your 4 devices before this court session?" Simon said, "Yes." "And during that time, did you at any point consult with any technician, digital expert, or third party to manage or review the content?" Simon said, "No, I did not. I handled it myself." The lawyer said, "Interesting. So we are to take it on faith that nothing was altered, deleted, encrypted, or hidden from forensic view, despite you having unrestricted access?" Simon said, "I understand your concern, but I assure the court that I did not alter anything." The lawyer said, "Mr. Simon, you are aware that modern devices allow users to permanently delete call logs, clear browsing history, or even remove entire conversations from messaging apps, correct?" Simon said, "Yes, I am aware of that." The lawyer said, "And these actions, when performed properly, can leave little or no trace for average observer. Wouldn't you agree?" Simon responded by saying, "Yes, but I did not engage in any such activity." The lawyer continued by asking, "You also understand that devices can be wiped, factory reset, or manipulated using third-party software?" Simon said, "Yes, but I didn't do that." The lawyer continued, "Do you expect this honorable court to accept without independent verification that you, facing serious charges, did absolutely nothing to alter or conceal data on your devices while in full control of them?" Simon said, "I have done what the court asked. If further analysis is required, I have no objection." The lawyer continued by saying, "Very well. Now, let's discuss backups. Do your devices sync with any cloud account, Google Drive, iCloud, Dropbox, or similar platforms?" Simon said, "Yes, I believe some of them are synced to cloud storage." The lawyer responded by asking, "Which ones?" Simon said, "My phone syncs with Google Drive and the laptop with a personal Dropbox account." The lawyer asked, "Have you granted the court or the prosecution access to those accounts?" Simon responded by saying, "Not yet. I was not specifically asked to." The prosecuting lawyer continued by saying, "Let me put it to you that the failure to disclose full access to synced accounts makes your submission incomplete and raises questions about your sincerity." Simon said, "With respect, I did not mean to hide anything. I'm prepared to give access if required." The lawyer continued by saying, "Let me press further. Have you ever used secure apps such as Signal, Telegram secret chats, or encrypted folders to hide communication or sensitive files?" Simon said, "I have used Signal and Telegram, yes, but not for anything illegal." The lawyer said, "Are those apps currently installed on your phones?" Simon said, "Yes, they are." Lawyer continued by asking, "Have you cleared chat history or deleted conversations on any of those apps before today?" Simon said, "I didn't recall deleting anything recently, but some older messages may have been cleared automatically or by me earlier." The prosecuting lawyer said, "So you admit that there may be content that was once on the device but is no longer present?" Simon said, "Possibly, but nothing relevant to this case." The lawyer said, "Simon, with all due respect, it is not for you to decide what is relevant or irrelevant. That is for the court to determine, based on your complete access to unaltered material. Do you understand?" Simon said, "Yes, I understand." The lawyer continued by asking, "Are you willing to provide passwords, recovery keys, and authentication access to your cloud accounts, encrypted folders, and secure apps right now in open court? Simon said, if the court directs me to do so, I will comply. The lawyer also said, let me also ask, have you used any third-party software to clean, scan, or optimize your devices before the court session? Simon said, I might have used a basic cleaner app on the phone, but not to delete anything intentionally. The lawyer continued by saying, so, even that could have removed data unintentionally, would you agree? Simon said, it is possible, yes, but I didn't use it to hide anything. The lawyer said, Mr. Simon, let me put it to you clearly. You had the means, time, and technical ability to interfere with data on these devices. You were not under supervision. Yet, you now ask this court to trust that every file, every message, every trace of activity remains untouched. That, respectfully, is not a standard this court can rely upon without expert verification. Simon responded by saying, I understand your position. Counsel, I have said I'm willing to submit for forensic review. At this particular point in time, the presiding judge had to step in and end the whole conversation because it was getting too lengthy. The presiding judge stated, and I quote, thank you, counsel. That will be noted. The court will now determine the appropriate next steps regarding forensic examination and access protocols. Meanwhile, the prosecuting lawyer asked the judge to grant him the permission to bring in a forensic expert to give or to react to the statement coming from Mr. Simon. Yes, so let's listen to the words coming out from the prosecuting lawyer on why and how he wants a forensic expert to testify or to be cross-examined in the court session. The prosecuting lawyer states, and I quote, much obliged, my lord. Having listened carefully to the defendant's submissions regarding his electronic devices and having conducted a brief cross-examination to test the reliability of those claims, the prosecution is respectfully compelled to seek the leave of this honorable court to call a digital forensic expert as a witness. My lord, while the defendant maintains that he has not altered, deleted, or concealed any material from the devices presented, there are significant inconsistencies and gaps in his account. He admits under oath to having full and unsupervised access to these devices before the court session kickstarted. He further concedes to using cleaner applications and to the potential existence of cloud storage and encrypted communications, all of which may or may not have been tampered with, removed, or manipulated. In light of these submissions or admissions, it is no longer a question of mere compliance or good faith. The issue before us now is one of authenticity and credibility. We cannot, my lord, rely on the mere word of an accused person who had every opportunity, every motive, and every means to alter the content of those devices. To do so would be a disservice to the administration of justice. Therefore, we respectfully request that the court permit the prosecution to present a qualified forensic officer who can conduct a thorough, expert-led examination of defendant devices. This officer will independently verify whether data has been recently deleted or tampered with, whether secure folders or hidden applications exist, whether any relevant communications have been masked, encrypted, or scrubbed from the memory, and whether cloud-based materials or external backups were excluded from the defendant's submission. Such forensic assessment is crucial not only for the truth-finding process, but also for the fair and balanced evaluation of the defendant's bail application. Without it, the court would be left to rely on unverified narrative from a party with a clear interest in the outcome of these proceedings. My lord, our request is not made to delay or frustrate the process. It is made in the interest of justice, transparency, and accountability. We therefore ask that the court grant leave for the appearance of forensic analysts at the earliest opportunity and direct that the defendant's devices be preserved, secured, and handed over for independent digital examination. Thank you, Your Lordship. At this particular point in time, the presiding judge granted the prosecuting lawyer the right and the permission to bring in a forensic expert to cross-examine and to testify in the court session. Yes, this forensic expert walked up to the stand and he started by saying, with your permission, my lord, I will proceed. My name is, he mentioned his name, and I serve as a certified digital forensic examiner with a company which he mentioned. I was directed by this honorable court to conduct an independent forensic analysis of the electronic devices submitted by the defendants, specifically 1 tablet, 1 laptop, and 2 mobile phones. I now present my professional findings to the court. Firstly, regarding the defendant's claim that no data was deleted or altered. Before the court session, our forensic tools detected clear signs of data deletion on all 4 devices. On the primary mobile phone, deletion logs revealed that multiple WhatsApp conversations and Telegram threads were cleared manually within a couple of hours back. These deletions were not accidental or system generated. They were deliberate and user initiated. On the tablet and laptop, several files, mostly in the downloads documents folders, were removed within the same time frame. The recycle bin on the laptop had been emptied, and several temporal file traces, such as the use of third-party cleaning software to wipe browsing history, cookies, and cache data. Secondly, on the issue of cleaner applications, contrary to the defendant's assertion that any cleaning app used was for general maintenance, our analysis confirms the installation and use of an advanced device optimizer tool known for having a secure deletion function. This tool was last run a couple of hours before this particular court hearing. As you can clearly see, this is a forensic expert giving a clear and definitive analysis of what he and his team found from Simon's phone.
All right, it is quite alarming, and it is actually painful to know how the Prime Minister Simon Èkpás case has actually taken a twist. But the good part of this case, and one thing I am sure about in this case, or this trial of Simon Èkpás happening in Finland, is the fact that, come what may, Simon Èkpás is coming out as soon as possible. We are sure about that. And even the enemies of Biafrans, the enemies of Simon Èkpás and the zoo government are already in the know. I believe strongly that they know about it. That is why they've been silent, recently on, how the trial has actually taken another twist in favor of Simon Èkpás and Joko. That is why they're not even talking about it so much. But having said that, there is something that is actually happening currently in the BRGIA, in the Biafra Republic government in Ezai. The team, how they've all started exposing a lot of things to the extent that your leader, the Prime Minister Simon Èkpás, is having an issue. He was arrested. He was arrested because of his fight, his struggle for Biafrans, which Biafrans has also contributed a lot to. And you feel that that is the right time for you to start bringing up all kind of propaganda. Whoever is right or whoever is wrong, for me, I don't care. But the most important thing is leaving the legacy that Simon Èkpás dropped before, being arrested. There was a pattern, there was a way things were structured. There was a structure he left, rather. And that structure have helped build, his government. Despite the wins, wins from people who have been fighting him, wins from Sabos, wins from the zoo government, who are doing everything possible to bring him down. So many wins. Yet, because of the structure he built and the foundation he built in that structure, he was able to overcome them. That is why it still baffles me that we are actually talking about what is happening, within the Biafran Republic government in Ezai, where there is an issue, APM, COS, and the rest of them having all kind of issues, forgetting the major thing that is happening. which is the structure that Simon Ekpa Njoku left. But they forget one thing, that Simon Ekpa is not going to be there for long. They feel, this is a case of Mazi Nnamdi Kanu in the zoo. We know the zoo and their structure of illegality and corruption. So they try as much as possible to twist things the way they want it. So they felt that was going to happen. But it is totally different in the case of Simon Ekpa, because the case is going smoothly and is going as fast as possible. And in no time, Simon Ekpa will be out of that place. So we are hoping and we are praying that, the court ruling and the final conclusion, verdict, comes as quickly as possible in favor of the Prime Minister, Simon Ekpa Njoku. Thank you once again for joining us. Please do not forget to share this video to as many groups and platforms as possible.